Ladies and gentlemen, now I come to the other part of this topic, that is nature of the right of the preemption. Uh, it is preemption basically is a kind of preferential right. It is a right of the substitution. It is a right in the exercise of which one owner of adjacent property sold to another person is entitled to dislodge the stranger who is likely to cause inconvenience to him. Therefore, the right of the preemption is a kind of the preferential right which is given to the owner of the property to purchase another property adjoining to his own, or of which he is the co-owner, or in which he is entitled to immunities or appendages. This right of redemption must still matter is finally decided by ultimate court. In Altaf Rai versus Gauri Shankar, 1927, a dispute arose over whether a person who was neither a co-sharer nor a neighbor could claim the preemption. The court ruled that right of the preemption is available only to those who fall within the specified categories under Muslim law, such as co-sharer or adjacent owner of the property. In in Bishan Singh versus Khajan Singh, Supreme Court observed that right of the preemption is right of substitution but not of repurchase. The preemptor takes the entire bargain and step into the shoes to the original vendee. But friends, before this decision, two cases were decided by the different high courts. One case was decided by uh, just by Calcutta High Court in 1869, and the name of that very case is Sheikh Qudratullah versus Mohni Mohan Sahab. The Calcutta High Court in this case, while dealing with the nature of right of the preemption, stated that sale of immovable property is subject to the right of the preemption passes on the full ownership to the purchaser. The right arises after the completion of the sale of that property. They opine that right of the preemption is a mere right of repurchase by the preemptor from the vendee, not from the vendor. So, in Sheikh Qudratullah versus Mohni Mohan Shah, Calcutta High Court explaining the nature of the right of the preemption under Muslim law clarified that right of preemption is not a right of substitution, but it is a right of repurchase not from the vendor but from the vendee by the preemptor. And the court also held that this right of the preemption, since on the sale of the property, the full ownership has passed on in the vendee, therefore vendee cannot be deprived of it. This was held by the court in Sheikh Qudratullah versus Mohni Mohan Sahab. But in 1885, again the matter on preemption came for consideration before Allahabad High Court. And Allahabad High Court in Govind Justice Mahmood in Govind Dayal versus Inayatullah, year 1985, held that like easement, the right of preemption goes with the land, and also easement right of the preemption to that right gives the birth. After 16 years of the above, the nature of the right of preemption was explained by Allahabad High Court in Inayatullah vs. Govindara. It held that right of the preemption as property has been sold to any other person. The co-owner claimed the property had to pay the same amount as would have been paid by any stranger or vendee to the vendor. So the sale of property itself is not the way of preemption or cause of the preemption, as the right arises after the sale, but circumstances surrounding the property. The right exists independent of sale, gives the preferential right to the preemptor. So now I move on to discuss kinds of preemption. What are the different kinds of the preemption, or who are the persons or owner of the property entitled to claim the right of the preemption and right of the preemption or haqq-e-safa. According to the Muslim law, right of preemption is available to the owners of preemptive only, that is to the following three types of the owners. Meaning thereby that right of the preemption under Muslim law can be claimed only by the three classes of the owners of the properties. One of them is called as Safi Sharik. Safi Sharik. Safi Sharik. That is co-owner in the property. Safi Sharik is called as co-sharer or co-owner in the property. The other type of the owner who is entitled to claim the right of the preemption is called as Safi Khalid, the preemption based on the immunities and appendages. The third category of the owner entitled to invoke the right of the preemption is known as Safi Char, preemption on the basis of right of the preemption based on the neighborhood or vicinage. So as such, are these three type of the or kinds of the or classes of the owner of the properties are entitled under the Muslim law to exercise or claim the property back in the exercise of the right of the preemption. And that is Safi Sharik, co-owner or co-sharer in a property. Who is co-sharer? I have already explained this. Say for example, this is the property X, and this X property has devolved by succession on the two persons A and B. So now by rule of succession, here they will be entitled, A and B will be entitled equal, will have the equal right in the property X. That is, A will be entitled to 50% and B will be entitled. So until the actual division of the property, they are the co-sharer in the property X. A and B both are the co-sharers. And therefore, one co-sharer is entitled to claim the preemption against his co-sharer, other co-sharer. And they are A and B here in this case for the purpose of the preemption will be called as Safi Sharik, means they are sharer. They are the sharer or joint owner in a property. The other is known as Safi Khalid. For example, suppose there is a property X and there is another property A, property B. Now there is a road or there is a staircase which joins to both the house properties A or there is a road, say for example passage connected to the property A and property B. So this road may be regarded as common immunity in respect of the property A and property B. If this is the situation, then they will be called here A and B will be called as Shafi Khalid, that is preemption based on the particular immunity or appendage. Then the other category of the person is who is entitled to claim the right of the preemption, that is Shafi Char. That is when two persons being the owner of the property, when there are two properties and both the properties are in close conjunction or they are in the neighborhood of each other, then both the owner will be called as the Safi Jar in a property. I have already given the example that, say for example, this is the case, this is the property and this is another property. A is the owner of this, B is the owner of this. Now there are two properties, one in the ownership of A, other in the ownership of B. Now A and B in respect of the properties are the neighbor for each other. They are neighbor of each other because both the properties are very close to each other and they are under the ownership of the different persons. So here they will be called as Safi Jar. So according to the Muslim law, if there are two co-owners in a property or there are two sharers in a property and one sharer or co-owner is intending to transfer his property by sale, then he is required by law of the preemption to give the information first or should make the offer of the sale of his share to his co-sharer, maybe A or maybe B as the case may be. If one co-sharer has sold the property without any information to his partner, then the other co-sharer will be entitled to claim the property back in the exercise of his right of the preemption, and his right will subsist on the basis of a particular relationship. That relationship is the relationship of the co-sharer in the property, and therefore he will be fully justified to claim the right of preemption on this ground. Then other kind of the person is Safi Khalid, means if two persons are, if there is a appendage or immunity and immunity is in the common use, one of the co-sharer is deciding to sell his share in the property, then since he is the common user in the appendage and facilities, then before selling it he should inform of his intention to the preemptor, and in this way preemptor can claim the property back, otherwise not. Safi Jar, he is another category of the person. I have already given the example, but remember that only these three classes of the owners are entitled under Muslim law, under the classical Muslim law, traditional Muslim law, to the right of the preemption. Other than these three owners, no other person will be entitled to claim the right of the preemption. Now, who is Safi Sharik? This is the point. Safi Sharik, I have already told that he is the co-sharer in, they are the Safi Sharik are co-sharers in the property, in immovable property. Sharik, co-share are co-owner of an undivided share in the property. If his other co-share owner sells his share to someone without first offering it to his co-sharer, then co-owner has a right to claim it back from the outsider. Nothing except sale will bring to the life the right of the preemption. So lease or mortgage will not attract the preemption. Under Shia law, this preemption can be claimed only when the number of co-sharers are two. Shia law is entirely different. That suppose there are there is a property, and in this property sharers are only two, A and B. But if sharers are three, the law of the preemption will not arise according to Shia law. And therefore Shia law is little bit different from Sunni law on this point. Sir Abdul Rahim says that reason why this right is allowed is that introduction of stranger is likely to give rise to the dissension and dispute, inconvenience, and the principle on which it is based that each co-sharer having the right in every particular party, one co-sharer selling his share would thereby affect the enjoyment of his share by other co-owner. And this he cannot do without his consent. So right of the preemption based on co-ownership or co-sharership is fully justified, has been justified by Sir Abdul Rahim. Safi Khalid, I have already told that he is preemptor. This preemptor is called as participator in the immunities or facilities. For example, exemption from some liability to which others are subject, entitlement to live in colony. So, Safi Khalid means when the two persons are owner of the different plots or different houses, but there is a common immunity for of them. Say for example, there is only a single water line passing through both the houses. So here both will be participated in the amenities, and therefore if either of them is selling his house, first of all he should make offer of the sale to his neighbor, so that he can not feel disturbed because of the introduction of a new stranger in their locality. Safi Khalid, when there are two owners of the two different properties, and both the properties are nearer to each other, they are adjoining to each other, then he will be both the owner will be called as Safi Khalid. And Supreme Court of India, in a famous case Bhau Ram vs. Baijnath Singh, has categorically held that right of the preemption based on the co-ownership is valid. When based on certain appendix like common air staircase, common interest, etc. But in another case, it was held that by the Rajasthan High Court that right of the Safi Khalid cannot be claimed against the right of easement of or light or air. It can only be claimed against the right of the way and right to water as given under Muslim law. The owner of neighbor of adjoining immovable property, he is called as Safidar. The Supreme Court in Bhau Ram vs. Baijnath held that on the ground of business as specified under the secular law will not be applicable to the decision of the Supreme Court. Another case is Razzaq Sajan versus Ibrahim Haji Sajan. In this case, Supreme Court held that law of the preemption based on vicinage and neighborhood was wide and unconstitutional. The claim was disallowed. So, still under Muslim law and as well as under the modern legal system, Safiya Sharik, that is legitimacy based on co-ownership, Safiya Khalid, that is a participator in the amendments and this is violated. Otherwise, law of the preemption will not be violated. So, the right of the preemption on the ground of the vicinage does not extend to the state of large magnitude, but it is confined to the houses, gardens, and small piece of the land. If there is more than one preemptor belonging to the different categories, the first category or class exclude to the second, and the second exclude to the third. But if claim be made by two or more persons belonging to the same class, they are entitled to the equal shares of the preempted property on tendering their rights respective quota of the purchase money. Illustration. For example, suppose there is a building which is situated in a street which is not a public thoroughfare and belongs to the only two persons, suppose A and B. Suppose there is a building, mansion or building situated in a street. Suppose this is the street coming to this. And this big property belongs to the two persons A and B. And they are having a common entrance here. They are coming through this street. This is the common street which is being used by A and by B. Here A start from here and enters into his property. B start from here and enters into his property. So here they are having the common facility to enter into their respective houses or properties. That is the right to entrance which is common. Therefore, they are participated in the immunity or in the common facility. Therefore, they will be here A and B will be called as Safi Khalid. And if A is selling his share, he is under the obligation to inform the B, and if B refuses, only then A can sell this property to somebody else, that is for C. But if he accepts the offer of the sale, A will be bound to sell the property for whatever price he wishes to the only B. If the A has sold the property to C without informing to the participant in the appendix, here B will be preempted and he will be entitled to dislodge the C and claim back the property. So, participator in the appendage and immunities, they are also a good stakeholders and they are entitled to exercise of the right of the preemption. If they all surrender the right, it belongs to the owner of any house or immediate continuous to the house in question, even though not abutting on the private estate. In the case of Sakina Bibi versus Amiran, 1888, it was held that Sufa is exercised against the owner of the property. It is immaterial whether he has possession of the property or not.